My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we continue our video series designed to educate and inform the public. So please subscribe to our channel. You've gone to court, you've had a custody hearing, and you've gotten an order. You're not happy about that order. You don't like what the order says. You feel that you've been treated unfairly. You feel the other side has been given benefits of the doubt to which they are unentitled. What do? Well, number one, you have to review the custody order. Make sure you understand what it means. Make sure you understand how much time with dad and how much time with mom. What does it really mean? Don't get bogged down by terms like sole custody or major custody, terms that would seem to suggest a particular title, a label, if you will, on the type of custody you have. Forget about that nonsense. Don't be impressed with the terms. Look at the overnights. How many overnights with mom? How many overnights with dad? If you feel that something is going on that supports modifying that order because you don't like that order, because maybe it gives mom too many overnights or maybe it gives dad too few overnights, whatever it is, you don't like the order, you're going to have to modify it. In order to modify it, your lawyer is going to have to file an appropriate motion and show the court that there's been a change in circumstances that supports revisiting that order. In order to do that, you're going to have evidence. You're going to have to show that something has changed, which would make the same judge who wrote that order, who thought it was reasonable before, make him or her change the mind. And in order to change that mindset, you're going to have to show that there's a significant change in circumstances, and you're going to have to prove that it's in the best interest of the child to make this change. If one person has alternating weekends and one overnight during the week, that's like 7 or 8 overnights in a month. If you don't like that because you think it's too much, understand what that means. One person's got, let's say, 8 overnights to your 22. Are you really going to come to the court and say that that's unfair? That you don't like that arrangement? Or the other way around? If the other side says, I don't have enough time, are you going to go to the court and say, well, I think that's fine, I think that's okay? Because you might do that, and the court might agree with you, after all. It's the same judge that gave that order. On the other hand, expect the court to say, you think that's okay? Well, do you think it's fair if I give you the 8 and give him the 22? How about that? Maybe it's not so fair at that point in time. So, in other words, be very careful with what you ask for. Understand that the judge, and oftentimes the same judge, is going to be handling all post-judgment issues until these children reach the age of majority. So you want to be reasonable. You want to show that you have a good faith opportunity, a good working relationship with the other person. You want to do all that. But it doesn't mean you should allow yourself to be taken advantage of, but it does mean you should try to work in a cooperative spirit to deal with that. So if you're upset about your custody order and you can't work it out, file the motions, but understand first what it means and understand that the court has options when it sets aside a custody order. It can keep it the same, renew the order. It can give you what you want. It can take away some of your time. So you got to watch with that. If you have any questions about your case, reach out and we'll be glad to help you out.